welcome all the participants and the dignitaries in this webinar organized by the North Zone under the chairmanship of Advocate Anuj Bansal. I am C. Rajender Arora, the chairman of the study circle, GST study circle. I welcome our Deputy President of the AIFTP, National Deputy President of the AIFTP, Advocate Sanjay Kumar ji. I welcome our learned Speaker of the day, CA Manish Gadia ji, the past chairman of the WIRC, Regional Council of Western India Regional Council. And we have a special guest also with us, that is the chairman of Eastern Zone, Advocate Smith Saurabh ji, with us also. And our executive, entire executive is with us. All the everybody is welcome. At the beginning, I would like to request the chairman of the zone to give his chairman address to start with the program. I welcome Advocate Anuj Bansal ji. सर आप म्यूट हैं, अनुज जी आप म्यूट हैं.
Good evening, respected Speaker, C. Manish Gadia sir, Deputy President Sanjay Kumar sir, Convenor Indirect Study Circle Committee C. Rajender sir, other esteemed senior members, and dear professional colleagues. On behalf of AFTP North Zone, I extend a warm welcome to each one of you to today's webinar. It's truly encouraging to see such enthusiastic participation from members across the fraternity. As you all know, today's topic is legal intricacies in first appeal under Section 107 of the CGST Act. Is extremely relevant as we all know Section 107 governs the very first stage of statutory appellate remedy under the GST regime, and it carries with it several procedural and substantive complexities. From the limitation period, pre-deposit requirement, condonation delay, etc. There are a lot of complexities. With the volume of show cause notices and adjudication orders rising sharply, a clear understanding of the nuisances of the first appeal has become very important to safeguard our clients and to ensure effective representation. I am confident that today's deliberation will provide valuable clarity and practical insights to all of us. We are privileged to have with us CA Manish Gadia sir from Mumbai, a distinguished professional having vast experience, deep expertise in GST litigation. His practical approach, command over the subject, rich experience in handling appellate matters will undoubtedly make this session highly informative and enriching. I would also like to take this opportunity to place on record my sincere appreciation to Indirect Tax Study Circle Committee, Convenor C.A. Rajender ji, Co-Convenor C.A. Chavi Jain ji, for their unwavering commitment, dedication, tireless efforts in organizing one webinar after another in the field of GST. The consistency, the quality, and the depth of the program that you have curated for the benefit of our members truly reflect your passion and devotion for the profession. My sincere thanks to you for organizing these webinars. Sir, in continuation to this enriching series, I would like to make a humble request through this platform, considering that GST Tribunal, Appellate Tribunal, is now becoming functional and it is expected to play a pivotal important role in GST adjudication in the coming months. I request you to kindly arrange, Rajender sir, for you. I request you to kindly arrange a webinar in the month of June on legal intricacies relating to GST Tribunal. And I also request Rajender sir, you to please you yourself deliberate on this subject, as all of we know that you are delivering a lot of sessions, you are taking a lot of sessions on this subject. So with these words, I once again extend my heartfelt welcome to our esteemed speaker, CA Manish Gadia ji, and each one of you. I'm sure today's session will be insightful, interactive, and beneficial to all. Thank you very much. Over to Ranjan sir to take the proceedings forward.
Thank you, Anuj ji. Now I would request our Deputy President Sanjay sir to please bless us with his words of wisdom and directions for the program and for the zonal activities also.
Thank you, Rajender ji. Thank you so much. And good evening to all the participants and the members who are here in this webinar. At the outset, I congratulate and thank Mr. Anuj Bansal, the chairman of the North Zone. एक के बाद एक वेबिनार, and even the East Zone chairman जो यहाँ पे हैं, I would congratulate him also. They are working very hard, and this Golden Jubilee year, बहुत सारे वेबिनार कर रहे हैं ये लोग. And thank you for all the efforts to both the chairman and the teams. कन्वीनर साहब जो बैठे हुए हैं वो जीएसटी ऐसे लगे जैसे जीएसटी के ऑफिस में हम पहुंच जाते हैं. उनको इतना बड़ा बड़ा जीएसटी लिखा हुआ है इसके पीछे, लगता है जीएसटी ऑफिस में हम आ गए. एंड आई वेलकम द टुडे स्पीकर, चार्टर्ड अकाउंटेंट मनीष गाडिया जी फ्रॉम बॉम्बे, and he is an eminent expert in indirect tax litigation, and he has been the chairman of the WIRC in 2022, right sir?
The 21-22.
21-22. And Rajender ji bhi the in you are also there in the North Zone, Northern Regional Council. So let's come to the subject today. The subject is very relevant for the GST practitioners today. The first appellate stage under Section 107 of the CGST Act. We are facing challenging litigation. If you remember, when this law came, of GST law was introduced in 2017, so it was aimed as created as a very simplified and a technology-driven system. But ऐसा हुआ नहीं. It was supposed to be a very simplified law. But now we professionals are regularly facing certain problems, legal difficulties. Am I audible?
Yes, sir.
Okay. There are several issues which are before the appellate proceedings, like limitation issues will come. There is a mandatory pre-deposit related issues would be there. Portal glitches, as Rajender ji mentioned at the before this meeting. Then there are non-speaking and mechanical orders जो आ जाते हैं. Recovery proceedings भी होंगी. Rejection of input credit. बहुत सारे issues हैं जो कि we would be facing in these first appeal stage. Therefore, the role of the professionals, we professionals, becomes very important. Along with the knowledge of law, we must be also we should understand the strategy, what we should adopt in appeal, the procedural compliance, the documentation, and also the recent development in the judiciary, the judicial developments, recent judgments which have come up. We are fortunate that we have Mr. Chartered Accountant, Mr. Manish Gadia amongst us, who will be giving his insights on this practical issue. And I hope all our professionals would be benefited by his presentation. And before leaving this platform, I would ask a question to the guest speaker, Mr. Manish Gadia, the Chartered Accountant Manish Gadia. Sir, सुनाई पड़ रहा है मुझे?
Yes, sir.
Audible.
ये बताइए, आप फेडरेशन के मेंबर हैं कि नहीं?
Sir, you are mute. Manish bhai, you are mute.
सर, आज की तारीख में मैं फेडरेशन का मेंबर नहीं हूँ. मैं एक बार एक्चुअली फॉर्म लाया, फिर कहीं पे मिस हो गया. डेफिनेटली अरोड़ा जी का आया तो मैं सोचा था फिर मेंबर बनता हूँ. तो
सर, आपसे रिक्वेस्ट है कि यू बिकम द मेंबर ऑफ द फेडरेशन एज अर्ली एज पॉसिबल. एंड
डेफिनेटली इट इज द अपेक्स बॉडी ऑफ ऑल द टैक्स प्रैक्टिशनर्स एसोसिएशन इन इंडिया, सो इट शुड बी. मैं करता हूँ सर.
thank you so much sir. Thank you all the participants, thank you the convener, thank you the chairman, and now over to the convener. Thank you so much.
सर मनीष भाई, मेरी विनती है, जब आप अपना फॉर्म भरें तो रेफरेंस में मेरा नाम डाल दीजिएगा.
बिल्कुल सर, बिल्कुल.
सर, अब ये फॉर्म फिलअप करने की जरूरत नहीं है, लिंक आता है.
लिंक में
फिजिकल फॉर्म की जरूरत नहीं है.
लिंक में तो नाम डालते ही है ना सर.
प्रपोजल में तो लास्ट में आएगा. बट अब मैं मनीष सर से ये बोलना चाहता हूँ कि फिजिकल फॉर्म लेने की जरूरत नहीं है, मोबाइल से ही हो जाएगा.
मैं लिंक भेज रहा हूँ आपको अभी इमीडिएटली आफ्टर द प्रोग्राम।
यस सर, यस सर।
तो सर, संजय सर, बहुत बहुत धन्यवाद आपका। इट इज
थैंक यू।
indeed a privilege, a proud moment to have you always on our program and guide us, bless us, direct us. And now, before I request Jain Roop Jain ji, the past secretary, the present executive member of the zone, to read out Manish Bhai's profile. Anuj ji, whatever you have said next program, sir, consider it done. I will, with your, as per your direction, I will certainly, मतलब मैं जब सारी दुनिया में बोल रहा हूँ, इनफैक्ट अभी स्मिथ भाई के यहाँ भी तो घर पे ही बोला था, पे तो जरूर ही बोलूंगा और आई विल बी फीलिंग मोर प्राउड। तो कंसिडर इट डन, नेक्स्ट मंथ जो भी डेट हम आपस में डिस्कस करके वी विल फिक्स।
In fact, we are privileged. Thank you.
अरोरा जी, बिफोर बिफोर वील स्टार्ट द सेशन, मैं ये जरूर चाहूंगा कि अभी क्या डेवलपमेंट जिस स्टेट का चल रहा है, इफ यू कैन ब्रीफ मे बी इन 1 or 2 minutes to all the participants, so they will be aware कि what is the due date of filing of appeal etc. अरोरा जी।
सर 2 मिनट में तो मैं नहीं बोलता, मैं
नहीं
दो
नहीं, 2 मिनट में, बिकॉज नॉट टुडेज टॉपिक, बट क्या होता है सर, एक ट्रेलर दिखाना जरूरी है ना नेक्स्ट
ये
प्रोग्राम के लिए।
जो आपने अभी एक तो पहला सवाल पूछा कि भी जितने भी ऑर्डर्स 73 या 74 में 1 अप्रैल 26 से पहले कम्युनिकेट हो गए हैं, उनकी लास्ट डेट जो है वो 30 जून 2026 है टू फाइल ऑन द जीएसटी 80 पोर्टल। द मोस्ट इंपॉर्टेंट टू नो इज जीएसटी 80 पोर्टल इज डिफरेंट फ्रॉम द जीएसटी पोर्टल, रेगुलर पोर्टल विच वी हैव बीन यूजिंग फॉर फाइलिंग वेरियस रिटर्न्स। एंड जो 1 अप्रैल 26 के बाद डिलीवर होंगे उनके लिए रूटीन में जो सेक्शन 112 में टाइम लिमिट है वो 3 महीने की टाइम लिमिट है फ्रॉम द डेट ऑफ द कम्युनिकेशन ऑफ द ऑर्डर, और फर्दर उसको कॉन्डोन किया जा सकता है 3 महीने के लिए। भारत में लगभग 32 ब्रांच बेंचेस बैठेंगी, जिसमें कि प्रिंसिपल बेंच जो है वो दिल्ली में बैठेगी, और हर स्टेट में अलग अलग डिपेंडिंग अपॉन द साइज ऑफ द स्टेट, जैसे कि यूपी में 3 बेंचेस बैठेंगी, महाराष्ट्र में भी 3 बेंचेस बैठेंगी, हरियाणा में 2 बेंचेस या एक बेंच एक सिटिंग बेंच, दिल्ली में एक बेंच। तो साइज ऑफ द स्टेट के हिसाब से जो है बेंच का नंबर होगा अकॉर्डिंग टू द लिटिगेशन का जो साइज है उस हिसाब से। और जो हमारा 2 फीस पे करनी होती है, मतलब 2 पैसे जमा कराने, एक तो प्री डिपॉजिट जमा कराना है जो कि सेक्शन 107 में हमारे मनीष भाई सबसेक्शन 6 के लिए बताएंगे, और हमारे यहाँ सबसेक्शन 8 में 112 में जो है वो प्री डिपॉजिट है 10%, 107 में है 10%, 112 में है। और इसकी फीस जो है वो पर लाख 1,000 रुपए, और पार्ट देयर ऑफ का मतलब अगर 1,01,000 रुपया भी आपका टैक्स का डिस्प्यूट है तो आपकी 2,000 रुपया फीस जाएगी, ना कि 1,000 रुपया। पार्ट देयर ऑफ उसको राउंड ऑफ कर रहे हैं पोर्टल पे अभी फिलहाल, हालांकि रूल्स में ऐसा कुछ नहीं लिखा। तो ये कुछ बेसिक बातें हैं, तो जो कि आपको फीस और प्री डिपॉजिट भी देना है। बाकी तो खैर बहुत सारी बातें हम कर सकते हैं, तो जैसे मनीष भाई के आदेश पर मैंने आपको एक फिलर दे दिया। अब मैं रिक्वेस्ट करूंगा जैन रूप जैन साहब से कि अ, मनीष जी का प्रोफाइल पढ़ें, और उन्हें, वैसे तो उन्हें इंट्रोडक्शन की जरूरत नहीं है, ही इज अ फेमस पर्सनालिटी अक्रॉस द कंट्री, बट स्टिल इट इज आवर 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 रिस्पॉन्सिबिलिटी। सर प्लीज।
थैंक यू सर। बिल्कुल सही कहा आपने, काफी बार मैं भी सुन चुका हूँ सर को, और बहुत अच्छा आपका रहता है, लेकिन फिर भी एक प्रोटोकॉल है प्रोग्राम का। सीए मनीष जी, ए विजनरी लीडर एंड ए सीनियर प्रोफेशनल विद प्रैक्टिसिंग एक्सपीरियंस इन द फील्ड ऑफ जीएसटी एंड अडेप्ट ऑफ एकेडमिक डेवलपमेंट, एन exemplary writer for journals and co-author of various books with passions for inspiring professionals and students through imparting high-end quality education. यदि हम प्रैक्टिस सर की यदि प्रोफेशनल एक्सपीरियंस की बात करें तो आप सन 1997 से एज ए चार्टेड अकाउंटेंट के रूप में प्रैक्टिस कर रहे हैं, और आप जीएमजे एंड कंपनी चार्टेड अकाउंटेंट फर्म के अंदर प्रैक्टिस करते हैं, और मेनली फील्ड आपका जो एक्सपीरियंस है या आपका जो एक्सपर्टाइज है वो जीएसटी और इनडायरेक्ट टैक्सेस है। अनेकों बुक्स के आप ऑथर को ऑथर भी हैं, आपके रिसर्च पेपर भी आते हैं, जिसमें मेनली हम बात करें तो स्टेचुटरी ऑब्लिगेशन ऑफ कोऑपरेटिव हाउसिंग सोसाइटी पब्लिश्ड बाय WIRC ऑफ ICAI, co-author of handbook on valuation and handbook on EPC contract, both published by the Chamber of Tax Consultant। आपका जो है WIRC के रेफरेंसर में लगातार कंट्रीब्यूशंस आपका रहता है। रेगुलर कंट्रीब्यूशन टू द GST रेफरेंस पब्लिश्ड बाय GST PM contribution article on service tax, in income tax review monthly journal published by CTC, compiled the budget booklet published by GB Nagar CPE Study Circle of WIRC for the year 2005 से लेकर 2021 तक। एकेडमिक बात करें तो ये ए रिन्यूल्ड academician and an eminent personality with proficiency in delivering more than 750 lecture on service tax and GST at ICAI, Regional Council of ICAI, branches of ICAI, Study Circle, the Chamber of Tax Consultant, AIFTP, BCAS, GST PAM, CGPI, Management Institute, Institute of Company Secretaries of India, Indian Navy, Trade Associations and Corporates. 2021-22 में आप चेयरमैन ऑफ वेस्टर्न इंडिया रीजनल काउंसिल ऑफ ICAI के रहे हैं. Attend leadership role as past chairman of Professional Development Committee and Study Circle Coordination Committee for the year 2021-22, Career Counseling Committee 2019-20, and Indirect Tax Committee 16-17 of WIRC of ICAI. Invited to express view on GST, which is regularly telecasted on national TV as well as print media. Contributed for a special column in Navha Times newspaper with focus on addressing queries of reader on GST from May 2017 till May 2019. Represented before Commissioner of Sale Tax Maharashtra, Finance Minister of Maharashtra, and Union Finance Minister for State in respect of GST. Co-opted member of Infrastructure Committee 2004 and 5, Committee for Capacity Building of CA Firm and Small and Medium Practitioner of ICAI for the year 2010 and 11. Banking, Insurance and Pension Committee of ICAI 2015-16 and member of Study Group on GST formed by ICAI 2009 and 10. Co-opted member of Indirect Tax Committee 14-15 and 15-16 of WIRC of ICAI. Group leader of Indirect Tax Study Group of WIRC of ICAI for the year 15-16. Chairman of Student Committee 14-15 and Indirect Tax Committee 10-11 and 11-12 of the Chamber of Tax Consultant. Founder, convener and core group member of GB Nagar CP Study Circle of WIRC. Thank you, sir. Thank you.
Thank you, Jain Saab. As we can see, we have a towering personality with us, our own brother, Chartered Accountant CA Manish Gadia ji. Now, without being standing between you and him, I straight away request him to, sir, please present your deliberation and guide us, enrich us with your wisdom and knowledge.
So first of all, I thanks Jain Saab for your kind words, and thanks my friend Rajender Arora ji for giving me this opportunity to interact with the members of AIFTP, which is one of the apex body of tax consultant across India, North Zone, and Anuj Bansal ji, again my friend, for inviting me here. Respected Sanjay Kumar ji, Smith Saurabh ji, and all the participants. So it is always a pleasure for anyone or any tax professional, I should say, to speak on the platform of AIFTP. सबसे पहले अरोरा जी ने इतना अच्छा टॉपिक दिया, मुझे इसको और डिटेल में स्टडी करने के लिए मौका मिला. बहुत बहुत धन्यवाद अरोरा जी, once again. So what I'm going to discuss today is statutory framework and appellate hierarchy, forum jurisdiction and locus standi, the mathematics of limitation and condonation, constraint, mandatory pre-deposit, then procedure, pleading and additional evidences, power of appellate authority and no remand rule, order rectification and key case laws, etc. So these are what I'm going to discuss today. But before going to all this, but personally I feel is the litigation always in GST start with section 73 as well as section 74. So कोई भी लिटिगेशन है, कुछ भी है, तो सबसे पहले आपका जो शो कॉज नोटिस है वहां से ये शुरू होता है। शुरू तो उसके पहले से हो जाता है, ASFT 10 है या फिर आपका इंक्वायरी नोटिस है या ऑडिट है, किसी से भी हो सकता है। बट द फॉर्मल लिटिगेशन व्हाट वी कॉल इज स्टार्टिंग विद द शो कॉज नोटिस, एंड उसके बाद ऑर्डर आता है एंड देन द अपीलेट प्रोसीडिंग स्टार्ट। So it is very important for us to understand what is section 73 and 74 before going to appeal. So is this okay, Arora ji? I'll take up this in brief or directly I'll switch to 107. What you suggest?
सर आप बैकग्राउंड बनाकर चलिए।
Yeah. So मुझे ऐसा लग रहा है कि थोड़ा बैकग्राउंड होगा तो बेटर होगा।
जी।
So the section 73 says that where it appears to the proper officer, तो उसको लगना चाहिए ऐसा, उसको तभी ये चालू होगा। एनी टैक्स हैज नॉट बीन पेड और शॉर्ट पेड और एनालिसिसली रिफंड, और वेयर द इनपुट टैक्स क्रेडिट हैज wrongly availed और utilized for any reason other than the reason of fraud or any willful misstatement or suppression of fact to evade tax. So other than fraud or willful misstatement, etc. hai, then he shall serve a notice in section 73. And what should be the part of the notice is how much tax he want to demand or how much refund he want to reject. What will be the interest under section 70, under 50, and the penalty leviable. This should also be quantified as far as the section, as far as the show cause notice is concerned. The proper officer shall issue a notice under subsection 1 at least 3 months prior to the time limit specified by subsection 10. तो subsection 10 में इन्होंने क्या किया है, एक टाइम लिमिट स्पेसिफाई किया है up to which the order should be passed for a show cause notice which is issued under 73. तो उसके 3 महीने पहले एटलीस्ट शो कॉज इशू होना चाहिए, which was not the case under the erstwhile earlier indirect taxes law, because there they have given just a time limit for issuance of show cause notice, but there was no time limit for passing an order. But now this is first time they were giving a time limit for passing an order. It is a welcome change, what I should say. Then 73(3) में where a notice has been issued for any period, the proper officer may serve a statement containing the detail of tax not paid or short paid, etc. So I'm not going into each and every subsection of 73. 73(5) says that if person chargeable with the tax before the service of notice under subsection 1, or maybe the statement issued under subsection 3, pays the amount along with the interest payable thereon under section 50, then the proper officer shall not serve any notice. So he will not serve any show cause notice. Nutshell. But subsection 7 says that where the proper officer is of the opinion that the amount paid under subsection 5 फॉल शॉर्ट, तो अगर मुझे समझो 5 लाख रुपए की डिमांड थी, होनी चाहिए ऑफिसर के हिसाब से, बट मैंने सिर्फ 4 लाख की ही डिमांड पे की है, ऐसा अगर उसको लगता है, सो ही कैन इश्यू अ शो कॉज नोटिस इन रिस्पेक्ट ऑफ बैलेंस 1 लाख रुपीज, नॉट इन रिस्पेक्ट ऑफ एंटायर 5 लाख रुपीज, along with of course interest and penalty, whatever you say. But where any person has paid the tax along with the interest under section 50 within 30 days of issuance of show cause notice, then also the penalty will not be leviable. And after that, if he is paying and if this is confirmed, then the penalty will be restricted to 10% or rupees 10,000, whichever is higher of the show cause notice amount का जो भी है. And the time limit for issuance of order under section 73 is 3 years from the due date of furnishing of annual return. So what is annual return? We all know that after the end of the year, up to 31st December, you are required to furnish an annual return. सो अगर मेरा अप्रैल 25 का कोई डिफॉल्ट है, सो उसका एनुअल रिटर्न मुझे दिसंबर 26 तक भर सकता हूं मैं, और दैट इज द ड्यू डेट ऑफ फाइलिंग ऑफ रिटर्न. तो माय 3 years पीरियड विल बी कैलकुलेटेड फ्रॉम दिसंबर 26, एंड उसके 3 महीने पहले मुझे ऑफिसर को शो कॉज इशू करना है. Then next we come to section 74, in which also the show cause notice has been issued, can be issued. The difference between 73 and 74 is 74 is talking about if there is a reason of fraud or any willful misstatement or suppression of fact to evade tax, then show cause notice will be issued in 74. If there is no suppression of fact, etc., then it will be under 73. And 74 talk about the show cause notice should contain the amount of tax evaded, the interest under section 50, and the penalty equivalent to tax specified in the notice. So whatever may be tax will be demanded, 100% of penalty can be levied under section 74. 73, the maximum penalty is 10%. And here, again, the time limit has been specified in subsection 10, and which says that the show cause notice should be issued at least 6 months prior to the time limit specified. So 73, it is 3 months. 74, it is 6 months. And again, subsection 3 is in line with 74, which says that may serve a statement containing a details of tax not paid or short paid, etc., etc., etc. And 74.5 says that if any SSC before service of the notice under 74.1 pays the amount of tax along with the interest and penalty equivalent to 15%, then and inform to the proper officer in writing of such payment, then the no notice shall be served to the SSC. But similar to 73.7, 74.7 says that the proper officer is of the opinion that the amount paid under subsection 5 falls short of any amount actually payable. तो जैसे हमने देखा कि अगर 73 में भी एज वेल एज 74 में भी अगर 5 लाख रुपए का ऑफिसर को लगता है डिमांड है, बट एसएससी ने 4 लाख भरा है, देन जितना अमाउंट शॉर्ट है लाख रुपए का, ही कैन इश्यू अ शो कॉज नोटिस एंड डिमांड फॉर द इंटरेस्ट एंड पेनल्टी. In case of 73, if you make the payment within 30 days of issuance of show cause notice, along with the tax and interest, then no show cause, then proceeding will be concluded. But in case of 74, you have to pay the penalty equivalent to 25% over and above the amount of tax as well as the penalty. And the time limit here is the 5 years from the due date of furnishing of annual return. So मुझे 5 साल में ऑर्डर पास करना है और उसके 6 महीने पहले प्रॉपर ऑफिसर को शो कॉज नोटिस इशू करना है अंडर सेक्शन 74. So time limit for 73 for the past year, it has been extended due to Corona. So I have given a table and I will share this presentation with the Arora sir also. So I think Arora sir, you will distribute among the partners, so I'm participants. So I'm not going into giving which is the date for issuance of show cause notice, passing of order, etc., etc.
Yes, sir. Okay.
Same way I have given a table also for 74. So I'm not deliberating. But this section 73 and 74 both is applicable pertaining to financial year. If you see here, only I have given a table 23-24. But from financial year 24-25, any show cause notice to be issued, it has to be issued under section 74A, not under 73 and 74. So any notice pertaining to 23-24 till 23-24 will only be issued in 73-74, which is much relevant for whatever appeal we are going to file or going to have currently in the first appeal stage. So basically what they have done is they have merged 73 and 74 both and made a section 74A. So I'm not going into detailing of 74A because maybe for appeal, whatever we are discussing may not be relevant as of now. But what is important provision, what they have given in 74A is that what we discussed is if we pay before issuance of show cause notice or within 30 days of issuance of show cause notice, or maybe 60 days, now they have extended for 74 for fraud, etc. So all proceeding will be concluded if you make the payment, except any proceeding which is under section 132. What is section 132 is that the arrest power. So arrest proceeding will not conclude if you make the payment, if there is a whatever the 4 cases has been given in section 132. And further it says that where the notice under the same proceedings is issued to the main person liable to pay tax, and some other person and the such proceeding against the main person have been concluded. So suppose a company है which is the main culprit of maybe circular billing etc etc, एंड उसके नीचे और भी कुछ कंपनियों को या पर्सनल कैपेसिटी में पर्सन्स को अगर कुछ नोटिस इशू किया है, तो अगर मेन पर्सन की नोटिस कंक्लूड हो जाती है 74A में, देन अदर पर्सन नोटिसेज एंड पेनल्टी एक्सेट्रा विल आल्सो बी कंक्लूडेड. जब से इनकम टैक्स एक्ट आया है, जब से सर्विस टैक्स आया है, तब से वी आर डिस्कसिंग एंड वेरियस कोर्ट्स आर डिस्कसिंग व्हाट इज द सेपरेशन ऑफ फैक्ट. And in GST also, in the initial stages, we were struggling what is the separation of fact. But now in section 74A, with effect from financial year 24-25, they have given an explanation too, which says that for the purpose of this act, the expression suppression shall mean non-declaration of facts or information with a taxable person is required to declared in the return, statement, report or any other document furnished under this act or rule made thereunder, or failure to furnish any information on being asked for in writing by proper officer. So now the scope of this separation has become very, very, very wide. Previously, we used to take a stand in case of service tax saying that, okay, this information I have disclosed in my financial statement may not be disclosed in the return, then you can't say this is a separation of fact. But now they are very specifically mentioned कि आपने इसको रिटर्न में या जो भी डॉक्यूमेंट आप फर्निश कर रहे हो जीएसटी डिपार्टमेंट को, उसमें ये इंफॉर्मेशन अगर आपने नहीं दी तो इट विल अमाउंट टू बी ए सेपरेशन ऑफ फैक्ट. So meaning is now very, very wide enough to cover various things within a separation of fact. Sorry. Now next is appellate hierarchy under GST. The first is the adjudicating authority who issue a show cause notice and order in original under section either 73 or 74 or now 74A. And officer may be up to the principal commissioner can pass this kind of order. If any SSC is not satisfied, then he can go for first appeal, which is the appellate authority. The procedure, everything, etc. has been given in section 107. And the appellate first stage appellate authority will be either the joint commissioner or maybe the additional commissioner appeals. The next stage is GST appellate tribunal, GST. What Arora ji has given a brief to us before the session, and next session also he is going to take on that. The GST appellate tribunal. Then after that, High Court, which is formed under Article 226 or 227, where you can file constitutional writ jurisdiction also. Supreme Court, Article 136, special leave petition also can be filed with Supreme Court. And the first appeal is, it is very important to note that the first appeal is the primary fact-finding authority and merit stage. Success here often prevent prolonged litigation. So after that, it is difficult for fighting any fact-based cases. Who can file an appeal? A taxpayer or maybe the SSC. As per section 107 of CGST Act, any person who is aggrieved by an adjudicating authority's order, including registered person or maybe the unregistered person also, the person who may be liable to pay under reverse charge liability but not registered with the department, or maybe the input service distributor. All this kind of class of person can file an appeal if they are not satisfied or aggrieved by the order passed by the adjudicating authority. Same way, government or department on the direction of the commissioner can file appeal against any order issued by the adjudicating authority of the department. There is a restriction in case of department which says they cannot file the suo motu appeal without explicit directions from the revisional authority. So the matter should go to the revisional authority. Their approval is required before filing a appeal at the first stage against the order of the adjudicating authority. What will happen in case of deceased person? Who can file is the legal hire, can continue an appeal after the death of the appellant, or maybe if any company who is into the liquidation, the official liquidator is the proper person who can file an appeal. And limitation is that appellate under advance ruling cannot appeal on the same question, and a person not a party to the original proceeding ordinarily cannot appeal. So these are some of the limitations. The next is authorized representative, who can represent. Any person required to appear before an appointed officer, the appellate authority or appellate tribunal may use an authorized representative to appear on their behalf. The only exception is when a person is specifically required by act to appear personally for examination under oath or affirmation. So sometime department issue a summon and want to record a statement also. So they will issue a summon to a SSC only, or maybe a particular employee of the SSC. So in that scenario, only that person should appear. Otherwise, authorized representative can also appear before the authority and give the submission. Now the next question is, who is authorized representative? So authorized representative means a relative or a regular employee of the person. So any of the relative can also be represent SSC in case of individual, and a regular employee. What is the meaning of regular employee? Nowhere it has been defined. Many times we have seen that there is a group of a company and where a group CFO is there. But that group CFO is a designation. But he is an employee of maybe A Limited. Can he represent on behalf of B Limited where he is not an employee and he is not drawing any salary and there is no employer-employee relationship, but maybe a group CFO? So there is no clarity on this, but my view, in my personal view, he cannot be called as regular employee. of that B Limited is a regular employee of A Limited. So he cannot represent. That is what my personal view. Different views are possible on this. The next is an advocate entitled to practice in any Indian court, provided they have not been debarred. So any advocate, Indian advocate, I should say, can be authorized representative. Next is a chartered accountant, cost accountant, or company secretary holding a valid certificate of practice and who is not debarred. So my dear friend Arora ji is also a chartered accountant and having a big firm of chartered accountant. So in his firm, suppose I am an employee and I am also a chartered accountant, Manish Gadia, but I am not holding a COP. So can I appear as an authorized representative of any of the client of the Arora ji? So you can write in a chat box also. सर लोग हैं या चले गए?
We are listening to you, sir. We
लोग
are
हैं
here.
सर, सभी लोग हैं सर, सभी लोग
सभी लोग
हैं।
हैं सर.
कोई कमेंट नहीं आया चैट बॉक्स में, तो मुझे लगा पता नहीं कि शायद वन साइड चल रहा है तो लोगों को मजा आ रहा है या नहीं आ रहा है। आई डोंट
नहीं
नो।
नहीं नहीं, सभी लोग हैं, सभी
अब
लोग।
आना चाहिए।
ये रवि जी चैट डिसेबल्ड है, तो चैट इनेबल कर दीजिए।
कर दिया सर
जी।
Yeah. So if I am not holding a certificate of practice and working in a chartered accountant firm, then I cannot represent before any authorized representative, because in the earlier erstwhile law, you say a firm of chartered accountant was there as an authorized representative. So a firm of chartered accountant means any chartered accountant who is my employee but do not holding a COP can also appear on behalf of that firm, represent any client of that firm. But now that restrictions are there, so any of my employee should have a COP to appear before the authority. The next is the retired officer of commercial tax department, maybe the state or union territory. So maybe the state GST department, you can say, who served at least 2 years in a role not below a group B gazetted officer, can also represent any SSC. And the retired or resigned officer must wait for a period of 1 year after leaving their post. So ऐसा नहीं कि मैंने आज ही पोस्ट छोड़ी है और मैं कल से ऑथोराइज रिप्रेजेंटेटिव हो जाता हूं, वो अलाउड नहीं है. And then authorized GST practitioner acting on behalf of the registered person can also be authorized representative of that SSC only. There are certain disqualification. Certain individuals are strictly prohibited from acting as an authority. Lifetime disqualification. Any individual permanently debarred from the representing anyone if they are dismissed or removed from government service. There may be a temporary disqualification also, where a person who has been declared insolvent cannot represent anyone. And cross-jurisdictional disqualification means any person disqualified under a state GST or UT-GST is automatically deemed to disqualified under CGST also. So there are appealable order and there are non-appealable order. So not every order passed by GST officer can be appealed under section 107. So section 121 explicitly bar certain order. So first is an order of commissioner or other authority empowering any GST officer to exercise any power. So अगर कमिश्नर के पास कोई पावर है which we can delegate to any other subordinate to take any action, this is not appealable at all because this is an internal order. An order directing the transfer of proceeding from one officer to another officer. So SSC do not appeal and say नहीं मेरा तो केस इसी ऑफिसर के पास रहने दो. That is not non-appealable order. Then an order pertaining to the seizure or retention of books of account, registers, or any other document. So if any officer find that seizure is necessary and he has a threat that the SSC may manipulate or may change the records later on. So this order, if he serve to the SSC and seize anything, any document, etc., register, books of account, etc., then it cannot be appealed under section 107. And last is an order sanctioning prosecution under this act. So अगर prosecution का कोई order issue हुआ है, so you can't go for appeal under section 107. But what is the remedy in this kind of cases? You can challenge this specific order representing a writ petition under Article 226 before the High Court. So directly you can go to High Court, but it cannot be appealed under section 107 with the first appellate authority. Now coming to section 107 per se. Section 107(1) says that any person who is aggrieved by the decision of the adjudicating authority may appeal to such appellate authority as may be prescribed. And what is the time limit for filing of appeal under section 107 is 3 months. And how you will calculate 3 months? From the date on which the said order is communicated to such person. So Arora ji ने भी हमको कहा था कि time limit for filing an appeal before GST is 3 months from the date of order of communication. So what is the order communication or date of communication? How we will find out? You can write in the chat box. Okay, so we will discuss what is the communication maybe little bit later. Meanwhile, you can write in chat box what you mean. Yeah. So Asha Sharma ji has written communication when email received or a portal communication from the date of uploading, date of receipt of order via portal or email. So we all are clear that nothing to do with the date of order. Correct? It has to be 3 months from the date on which the order is communicated to such person. There may be a time gap between the issuance of order and the date of communication. So always the date of communication is very, very, very important. And always I suggest and recommend all my SSCs that you should always note that what is the date of communication. So this 3 months period is for the SSC when he is filing an appeal. But in case of department, the limitation period is of 6 months, not the 3 months. So they have additional 3 months for this. In case of cross objection, the department may file a cross objection within 45 days of receiving the notice of appeal. Then condonation of delay. Section 1074 says that if the appellate authority may, the word used here is may. So it is not necessary that fulfillment of all these conditions the appellate authority will condone. It says that may if he is satisfied that appellate was prevented by sufficient cause from presenting the appeal within the aforesaid period of 3 months or 6 months as the case may be, allowed to be presented within a further period of 1 month. So if there is a sufficient cause and if the appellate authority is satisfied subject to this fulfillment of this two condition, then additional period of 1 month can also be condoned. The appellate authority mathematically lacks the power to condone delay beyond this 1 month grace period. So if SSE is not able to file this appeal within the period of 4 months, or maybe filed after 4.5 months, so strictly speaking, section 104 does not give any authority to first appeal stage to give any grace period. And section 5 of the Limitation Act 1963 does not apply to the first appellate authority under GST. So on this, we have a judgment of Kolkata High Court, West Bengal, in case of Rajkumar Sinhal, where the SSC has received show cause notice, of which was uploaded exclusively under the offshore additional tab instead of the normal tab. So the order was, the show cause notice was communicated, but communicated in wrong tab. Furthermore, the date scheduled for personal hearing was inexplicably fixed before the deadline to file a reply to show cause notice. So reply can be filed within 30 days. So if notice has been issued on suppose maybe 1st May, so before 30th May, the PH cannot be fixed. And in this case, they have fixed the PH before 30 days, and ex parte assessment order was subsequently passed. And further, the SSC filed an appeal beyond the statutory 4-month limit, citing severe medical emergencies of its partner and the hidden nature of the portal notice. Both the appellate authority and single judge dismissed the appeal strictly on the ground of limitation. Then the matter went to the division bench of Kolkata High Court. And in case of limitation, the court said that the 4-month timeline under section 104 is directive and not mandatory. Therefore, section 5 of the Limitation Act applies, and delay was rightly condoned due to medical emergencies. So here the court has said that we will apply the limitation period of 5 months because of the medical emergencies and the wrong tab. We allow this appeal beyond the 4 month. And further it says that putting this as additional tab instead of normal tab does not constitute valid statutory communication. So properly it is not being communicated. So the period of 4 months will not be calculated from that period. And now what is the sufficient cause for condonation? From the various different judgment or various judgment in different law, I have able to find out 4 such kind of different ground. That is, 1, the medical emergency or hospitalization of the appellate or the counsel. Death or severe illness in family during the limitation period. Non-receipt of order at the registered address, or bona fide mistake by counsel without gross negligence can be the sufficient cause for allowing the appeal for extended period of further 30 days, what has been given in section 107. But again, it will be restricted to 3 months plus 30 days. And various court has rejected the following grounds to be a sufficient cause for condonation. ignorance of law is not a sufficient cause. So you can't plead that मुझे ये लॉ पता नहीं था, या मैं गांव से हूं, या मुझे ये पता नहीं है. All these kind of things are not acceptable. Then subsequent change of counsel, कि मैंने एक counsel को appoint किया था, बाद में I have changed this counsel, and because of the prior counsel negligence, it is not the responsibility of the government, it is the responsibility of the taxpayer, and the condonation cannot be granted on this ground. Next is the financial difficulties. जैसे सर ने हमको, अरोरा सर ने स्टार्टिंग में बताया कि 10% भरोगे तो ही आपका अपील एक्सेप्ट होगा. सो आप ये नहीं बोल सकते कि 10% भरने के लिए मेरे पास पैसा नहीं था, इसके लिए यू अलाउ मी द फर्दर 30 days पीरियड. Or simple oversight or fruitfulness without adequate explanation. These are the rejected ground for showing you a sufficient cause or allowing you the extended period of condonation. Next is, many participants has also given in the chat box saying what are the mode of receiving notices. Hand delivering the notice directly by a messenger, directly, or by a messenger via courier to the taxpayer or his representative. तो डिपार्टमेंट का ऑफिसर आपके ऑफिस पे आके भी सर्व कर सकता है, और वाया कुरियर भी भेज सकता है, और मे बी a registered post, speed post, etc. Then communication to the email address. And the last one is making it available on the GST portal after logging in. So it is very important. तो मैं हमेशा हमारे सब क्लाइंटों को कहता हूं कि जब भी आप ऑफिस में आते हैं, सबसे पहले भगवान को दिया और बाती करते हैं, और उसके बाद दूसरा सबसे इम्पोर्टेंट काम जो आपको करना है वो जीएसटी के पोर्टल पे जाना है और टैब में देखना है कि कोई नोटिस तो नहीं आया, कोई कम्युनिकेशन तो नहीं है, कोई लव लेटर तो नहीं है. तो आप ये चेक करते रहिए, because law is very clear and which says that mode of communication is also uploading a notice or maybe the order etc. on the GST portal. Then maybe a publication is regional newspaper being circulated in the locality that the taxpayer based on the last known residential address. So it may be possible that they are not able to find the SSE. All the four modes are not, they are not able to reach out to them. So they may publish in a regional newspaper, or may they affix a notice or order maybe at the prominent place of last known business place, or maybe the residence address of the SSE. And if this is not found as reasonable by the tax authority, they can fix a copy on the notice board of the concerned office. So आपको डिपार्टमेंट का साइट भी विजिट करते रहना जरूरी है, डिपार्टमेंट का फिजिकल भी. So there are certain issues as far as the date of communications are concerned. The limitation clock strictly begin on the date of communication, which is actual delivery, not the date of order was drafted or signed. So delivery is important. There is a landmark principle which says that if an order is not communicated at all in accordance with section 169, the limitation period does not begin. So communication से ही 3 महीने का या जो condonation period etc. will start from the date of communication only. Supreme Court has given some exception under COVID-19 situation. Suo motu, the order limitation was entirely excluded from 15th March 2020 till 28 February 2020 plus 90 days. तो इसके बीच में अगर जो भी ऑर्डर पास हुए हैं उसका अपील आप 28 फरवरी से फर्दर 90 डेज का पीरियड कैलकुलेट करके यू कैन बी एबल टू फाइल दैट. तो दे आर एक्सेप्शनल केसेस में दे हैव गिवन दिस. There are certain case laws also as far as this communication, mode of communication, etc. are concerned. One is Bambino Agro Industries, Allahabad High Court, where a batch of writ petition was filed primarily by a small and medium businessman challenging ex parte GST adjudication order passed under Section 73 and 74. The petitioner contended that the show cause notice and the final order were only uploaded on the GST portal and never effectively communicated to them through physical mode. Consequently, they only gained knowledge of this order when recovery proceeding commenced, and by that time the 120 days statutory limitation has gone. Crucially, the GSTN admitted on affidavit that its system does not create an electronic log or trail to trace when the taxpayer actually view, open or download a notice or order from the portal. So this is not practically possible, and that they do not have a trail कि उसने कब notice को देखा है या order को देखा है. So here the issue involved was whether the mere uploading of show cause notices and adjudication order on GST common portal amount to effective communication to trigger the limitation period for filing an appeal under Section 107. The Allahabad High Court has set aside the ex parte adjudication order subject to a deposit of 10% of disputed tax amount and remanded the matter back to the adjudicating authority for fresh adjudication. The court rationale is as follows for doing this. They said the meaning of communication, merely uploading notices and order on the GST portal without effective and provable communication to taxpayer cannot be treated as valid communication. But many court has given otherwise view also. Limits of deemed service. Analyzing Section 169 of the Act, the court held that the legal deeming fiction of constructive service applies strictly to specific modes like physical tendering, speed post, publication, and affixation. The legislature deliberately omitted this deeming fiction for documents sent via email or made available on the common portal. And another ground what court has took is lack of knowledge, acknowledgement. Since the GSTN system lack of any mechanism to generate an acknowledgement or verify when an electronic record is actually retrieved or viewed by the addressee, no interference of actual date and time of service can be drawn. And natural justice, the court concluded that relying solely on the portal upload on this manner forces an ex parte nature of the proceedings, causes irreparable prejudice by extinguishing a statutory right to appeal and ultimately violates the principle of natural justice. And they said that you go and file the appeal with the first appeal while paying after paying the 10% pre-deposit requirement of Section 107. In another judgment, in case of Mathur Polymers, this is a Supreme Court judgment 2025-90 tax law. Here he has challenged and confirmed that a demand of approximately 81,51,000 regarding the alleged fraudulent availment of ITC was there. That petitioner sought a relief on the ground of the violation of principle of natural justice, claiming they never received a notice for a personal hearing. Furthermore, the petitioner objected to the legality of department issuing a consolidated show cause notice and order covering multiple financial period. Here the two issues they have raised. One is multiple year का जो show cause notice है वो consolidated, and they said the personal hearing का notice ही नहीं मिला. In the defense, the department presented evidence demonstrating that 3 separate hearing dates were communicated via email to the address registered on the petitioner's GST portal. So here it is important that in this case, the email has been sent by the department on a registered email address of the SSE. Here also I want to communicate to the participants that many times we have seen that you always give an email ID of any of your employee. And maybe after 2 years, 3 years, 4 years, if that employee leave your organization, then nobody is operating that email. So it is important that immediately you go to the portal, change this email ID. Otherwise, the department may send a notice or may send an order to you on this mail, and then you can't say that I have not received anything because it is your mistake. So here the issue is whether the service of personal hearing notices via email to address registered on GST portal constitute valid service of notice under section 169 as whether a consolidated SCN, which is not the case for our today's discussion now. The Supreme Court dismissed the SLP, finding no good ground or reason to interfere with Delhi High Court judgment. The rationale as established by High Court was and upheld by Supreme Court is as follows: sending notice to email address registered on the GST portal constitutes a valid and adequate service of communication under section 169. The court observed that the petitioner concealed the receipt of this email while falsely pleading a breach of natural justice. Another judgment by Allahabad High Court in case of RIA construction. Here the issue involved was whether the failure to effective communication to show cause notice and hearing date constitute a violation of natural justice, thereby invalidating the ex parte assessment order. The Allahabad High Court quashed order, ruling that the failure to communicate hearing details breaches natural justice. So you have to communicate the date of personal hearing, and without that you cannot pass an ex parte order. Next is Anuj Bansal ji has talked about the pre-deposit requirement to be covered. Section 107 subsection 6 says that no appeal shall be filed under subsection 1 unless the appellant has paid a in full such part of amount of tax, interest, fine, fees and penalty arising from the impugned order as is admitted by him. So what is the meaning of this? It is the first requirement. So what it says is that a order has been passed by an adjudicating authority confirming a demand of 10 lakh rupees. Out of 10 lakh rupees, I accept the liability of 4 lakh rupees, which is accepted by the SSE. So if you want to go for an appeal against this order, so section 1076A says that you need to pay the tax of rupees 4 lakh, interest to the extent of that 4 lakh rupees what you accepted, and any penalty. Suppose if this order is under section 73, then 10% of the penalty amount, and if the order is under 74, then the 100% of that 4 lakh rupees need to be paid in full if you want to go for an appeal. This is not ending here. It further says that not only this, and over and above, you have to pay a sum equal to 10% of the remaining amount of tax in dispute. So taking this our example, so 10 लाख तो 10 लाख में से 4 लाख का टैक्स इंटरेस्ट पेनल्टी मुझे भरना है। उसके अलावा जो 6 लाख रुपया बच गया, विच इज द डिस्प्यूटेड अमाउंट ऑफ 6 लाख रुपीज, उसका मुझे 10% भरना है फॉर फाइलिंग एन अपील। दिस इज द मैंडेटरी प्री डिपॉजिट रिक्वायरमेंट। And pre-deposit is strict condition precedent. Non-payment renders the appeal non-maintainable and is not merely a curable defect. And this 10% calculation applies only and only to tax in dispute. Admitted tax, pay in full with interest and penalty. Only the tax in dispute, not the interest. तो जो हमने एग्जांपल लिया 6 लाख का मुझे इंटरेस्ट और पेनल्टी नहीं देना है, बट 6 लाख का टैक्स अमाउंट जितना है उतना उसका 10% मुझे दे देना है। Then in case of special cases, pre-deposit and statutory cap, the maximum cap is of 25 crore per appeal. What is the meaning of 25 crore? Means 25 crore CGST and 25 crore SGST. So means I need to pay either 10% of the tax amount subject to maximum 50 crore only. Again, it is disputed amount what we are talking. There may be a possibility that there is a only penalty order. And this is only post Finance Act 2025. So अगर मैंने liability accept कर ली है, मैंने वो टैक्स भी भर दिया है, इंटरेस्ट भी भर दिया है, now I am disputing only and only penalty amount, and order is only in respect of that penalty amount, because show cause के स्टेज पे ही मैंने टैक्स और इंटरेस्ट पे कर दिया है, and now I am disputing penalty. So in case of penalty order prior to 2025, without any pre-deposit, I can be able to file an appeal under section 107. But now 10% of the disputed amount of penalty also need to be pre-deposit to file an appeal. In case of e-way detentions under section 129, a separate and higher threshold applies, and filing an appeal against an order under section 129(3), order require a pre-deposit of 25% of the penalty amount need to be deposited. And refund of pre-deposit government governed by section 1078. If the appeal succeeds, the pre-deposit is refunded with interest under section 56. If delay beyond 60 days and is not constrained by the time limit of section 54. So जो भी मैंने pre-deposit दिया है, within 60 days of communication of order to the department need to give the refund. Otherwise, interest will also be paid by the department. Here again, Allahabad High Court, pre-deposit. Here the matter is that the SSC firm filed an appeal against an assessment order passed under section 74(9) of GST for the financial year 17-18. And they made a payment of mandatory 10% pre-deposit of disputed tax. But instead of making this payment from electronic cash ledger, they have made from electronic credit ledger. So first appellate authority rejected the appeal without touching upon the merit of the case, solely on the ground that the pre-deposit should have been paid through a cash only, not through a credit ledger. The SSC went to the Allahabad High Court, and Allahabad High Court, after hearing, found out that a government has issued a circular dated 6th July 2022, where they have made the payment toward any output tax, whether self-assessed or payable as a consequence of any proceeding initiated under GST law. So it's not restricted only to the self-assessment, but it also says that any proceeding initiated. So Any order issued under 73 or 74, it is also a proceeding initiated under GST. Can be legally made by utilizing the amount available in the electronic credit ledger. This circular they have issued. And the court held that since the firm has successfully made pre-deposit through a electronic credit ledger and there is no requirement as far as this circular is concerned, so appellate can make a pre-deposit through a credit ledger also. There are some practical portal challenges. The payment made voluntarily during an investigation or audit via form GST DRC 3 are not automatically recognized by GST portal for appeal generation. So there is a requirement that if you have an order, you need to make the pre-deposit of 10% of disputed amount. So DRC से जो मैंने पेमेंट पहले भरा हुआ है इन्वेस्टिगेशन के टाइम पे, तो उसका मैं क्या करूं? So what is the solution? The taxpayer must file a form GST DRC 03A to explicitly link their prior DRC 03 payment with the specific demand ID generated by the order in original as per GST. And for this, they have issued a GST and advisory also. So if you have made any payment earlier during an inquiry stage, you can adjust again a pre-deposit requirement. This section 1077 is very important, which says that where appellate has paid the amount that pre-deposit under section 1076, the recovery proceeding for the balance amount shall be deemed to be stayed. So, matlab, there is no separate appeal to be filed, there is no separate application to be filed, not to initiate any recovery proceeding. Some practical strategy. Filing an appeal operates as an automatic statutory stay of recovery for entire remaining amount without requiring a separate stay application. So there will not be any bank attachment, no garnishing notices, no coercive action can be taken. So what is the procedure for filing application APL1 form? First is obtain the order, secured a certified copy of order in original and precisely note the date of communication when the uploaded on the portal, maybe a physical receipt, maybe a email if you have received. So that also need to be mentioned on the order because the 3 months period, etc. start from the date of communication of order. And you need to take a certified copy of the order in original. Then file form APL1 on GST and portal attaching the statement of facts, ground of appeal, order, and the pre-deposit challan. These are the minimum requirements. Third step is form APL02 will be issued within 7 days acknowledging that the appeal has been filed. This APL2 does not amount to that the appeal has been admitted. It is only that you have filed an appeal. The appellate authority may issue an defect notice. So it is the duty of the SSC to rectify the same. If they are not rectifying within the stipulated time, it will dismissal of the appeal. Next is drafting grounds of appeal. Some professional do's and don't also very important. So first of all, correlate every single ground with the specific corresponding finding in the order. If he has given various reasons in the order for disallowing something by the authority, adjudicating authority. So each single ground, whatever you want to take, maybe you can take a multiple ground on a single point also, but it has to be a different ground, and the ground should be very specific to what you want to communicate. You should also raise a jurisdictional objection, maybe time bar SEN. SEN has issued beyond the time limit, or as primarily or preliminary ground. Separately and explicitly raise procedural violations such as flow in the show cause notice, denial of natural justice, that what we discussed, PH notice has not been served. You have passed an ex parte order without giving the opportunity of being heard, or you may have passed a non-speaking order. So specifically, it has to be also raised in the ground of appeal. You can file appeal maybe on the ground of fact, the fact which is not correct, or you may be disputing a question of law. So don't merge this two ground together. Fact should be in the appeal, fact should be given separately, law point should be given separately. First appeal authority have the jurisdiction over both the points, so it has to be given both the points separately. You should also cite relevant statutory provisions, the circular, advance ruling, any binding case laws, any provision of the law, any notification which may be in your favor. So that also need to be quoted. So these are some of the do's and don't, because there is no straight jacket formula that while filing your drafting ground of appeal, this should be there. It depend on the order, or maybe the whatever the lapses has been made by, if any made by the authority, you should highlight that lapses and claim the benefit. There are some of the don'ts also for drafting of ground of appeal. We should not use vague or sweeping language, saying that the order in law or the order is bad in law without statutory backing. So this is a human tendency that अगर मैंने कुछ गलत भी किया है, so आप मुझे आके कहोगे कि मैंने गलत किया है, so I will not accept it, I will not like it. So it is very important that when you are saying the order is bad in law, you have to substantiate also why it is bad in law, with some fact, with some reasoning, with some laws, case laws, etc. Don't raise entirely new ground what were not taken before the adjudicating authority. You can take a new ground, but there has to be a strong legal justification that why you have not raised this point earlier in the adjudication. Otherwise, you should not raise an entirely new ground. Don't merge multiple distinct legal ground into single, or maybe a confusing paragraph. Don't ignore litigation or pre-deposit issue if they exist. Don't raise new facts that are not on the official record without formally seeking leave to file additional evidence under Rule 112. So there are some natural justice or maybe the adjudication defects may be there in your order. So maybe first is jurisdictional and SCN defect, order traveling beyond the scope of the show cause notice. If show cause notice में उसने मेरे को एक reason दिया है, because as I said कि show cause notice should contain the reasoning, should contain the amount of tax, the interest, the penalty, etc. But if the order is traveling beyond the scope what is given in the show cause notice, then it is there is a defect. If vague SCN is there, or SCN not issued by the proper officer, or maybe time barred under section 7310 or maybe 7410, that what we discussed in the beginning. Then natural justice violations may be personal hearing not granted despite request or without request also. Because there is a judgment, I forgot to quote that judgment, which says that without giving a hearing, personal hearing, High Court has said that you can't pass an order even though the personal hearing has not been specifically demanded by the SSC while filing in reply to show cause. Then next is taxpayer's detailed reply is ignored, which is the most common thing what I have seen in the order passed by the authorities, adjudicating authority, that they ignore whatever the fact or figures you have given while filing a reply to show cause. Denial of opportunity to cross-examine witness. You have the right to cross-examine the witness if the show cause notice or the order is relied upon a witness or some other person's statement. So you can demand at the adjudication stage itself, or the absence of reasoned or maybe the speaking order. So these are the cases of natural justice violation. So you should raise this in your ground of appeal, saying that natural justice violations are there. Then requirement of hearing, already we discussed. Then rule 112, we say that fresh evidence not presented to the adjudicating authority is generally barred. However, section rule 112 sub rule 2 provide specific condition for admission. So ये अगर condition है, so you can give additional evidences where the adjudicating authority refused to admit evidence that ought to have been admitted. If you are submitting but adjudicating authority has not accepted, it means if you want to give additional evidence, you need to prove that adjudicating authority not allowed me to give this evidence. Where the appellate was prevented by sufficient cause from procuring evidence from the original authority. So in one of my case, I will just give that 2A and 3B difference pe they have issued an order. And the figure of what I have claimed, my SSC has claimed in 3B and whatever is there in 2A. At that point of time, it was 2A. Difference was between 2A and 3B. So both of the figures, what has been given in show cause notice, has been not matching, which I have already communicated to the adjudicating authority. So I have asked you, give me this detail from where you got this figure. So this kind of point also can be raised and additional if it has been provided after adjudicating or after order or anything, then sufficient cause and this fresh evidence can be admitted. Where the adjudicating authority decided the case without granting a sufficient opportunity to produce evidence. So at the time of hearing of adjudication, if some point has been raised by the adjudicating authority and you said, okay, sir, I need to give this evidence maybe within 7 days or 10 days, and the adjudicating authority is not allowing you to give time, then in that case, you can give a fresh evidence at the first appeal stage. And where the evidence relate to a point which the appellate authority requires for satisfactory adjudication. So all these 4 points you can allow to give the additional evidence. And if the conditions are met, the appellate authority cannot arbitrarily refuse to consider the additional evidence. It is the mandatory for the appellate authority to accept this additional evidences. The next is, what is the power of the first appellate authority? The appellate authority may confirm the order passed by the adjudicating authority. It means they can uphold the original order in full with the recorded reason. Next is, they can modify also. Maybe they can reduce the demand, alter findings, or partly allow the appeal. But definitely they cannot increase the demand. Then they may set aside the entirely and questioning the tax demand. So these are the three things what the appellate authority can do. This is very important, that no remand rule. So what happened in case of income tax and in earlier erstwhile law, we used to say that for at the first stage appeal also, sir, this has not been considered by the original adjudicating authority, you remand back the case, and they remand back the case to the original adjudicating authority. But in case of GST, the first appellate authority has no power to remand back to the original adjudicating authority. And there are various case laws to this effect also, multiple. The Allahabad High Court in case of Anand and Anand law firm, then in Madras High Court in the case of Shivam Steel, have consistently said that the appellate authority, first appellate authority, have no power to remand back. It is the responsibility of the first appellate authority, because they are the fact finding authority, and they have to take themselves do the analysis and take a call instead of remanding back the case. Next, the appellate authority passes the power to increase the taxpayer's liability, but a strict due process must be followed. And we say that if you want to pass an enhancing maybe the fees or the penalty or fine in lieu of confiscation, or confiscating goods of greater value, or reducing the amount of refund or input tax credit, shall not be passed unless the appellate has been given a reasonable opportunity of show causing against the proposed order. Supreme Court, there is a precedent which says that in case of Assistant Commissioner versus Chandra Bhavan, said that appellate authority's power to enhance is void if an opportunity to be heard is not granted. It is the violation of Article 14 of Natural Justice. Then the appellate authority also have a power of rectification of error under section 161. So statutory provision says that if anything is apparent from record, any mistake is apparent from record within the 3 months from the date of the order, it can be rectified. And what qualifies as apparent? Maybe the arithmetical mistake, clerical error, wrong transpositions, or the inherent omission of a factual finding already made on record. And what does not qualify as a mistake apparent from record is reappreciation of evidence, changing a legal view, or
मेरे ख्याल कुछ कनेक्टिविटी इशू है मनीष जी के साथ. यस, जस्ट वेट, ही विल ज्वाइन बैक. जस्ट वेट.
मुझे लगा हमारे यहाँ कनेक्टिविटी इशू है, उनका बंद हो गया तो।
पहले तो ऐसे ही लगता है सर।
हाँ, मैं अपना वाईफाई चेक कर रहे थे हम।
इस पर क्वेश्चंस भी बहुत सारे आ गए हैं चेयरमैन साहब।
Sorry, sir, it got disconnected from technical.
No issue, sir. In GST, we are habitual to these things. Technical glitches. So no issue. Please, you can continue, sir. Please.
सर,
शेयरिंग के लिए मुझे अलाउ करिए ना सर।
सर को
Sharing allowed है, sir?
अभी
नहीं, वो नहीं दिखा रहा है, द होस्ट इजंट अलाउड बिकॉज रीजॉइन
अच्छा,
किया
आपको एक बार दोबारा आपने दोबारा लॉगिन करा है? एक
हाँ, लॉगिन
मिनट।
मैंने दोबारा किया है।
और रवि जी हैं क्या अभी?
हाँ, रवि तो होंगे, रवि को
हाँ, नहीं नहीं, अभी हो रहा
हाँ
है।
सर, कोच कोच बना दिया उनको।
कोर्स बना दिया, ठीक है, प्लीज।
हाँ।
ऑलरेडी बहुत सारे मनीष भाई सवाल आ चुके हैं चैट
तो
बॉक्स में।
बस तो एक काम करते हैं, ये तो सर हमको पता ही है कि कौन कौन से इश्यूज चल रहे हैं, तो हम उसको स्किप कर सकते हैं। सो प्रोसीजर फॉर फाइलिंग ऑफ अपील, तो आई थिंक मे बी कवर्ड इन वॉट एवर।
अब थोड़ा सा आप ऐसा देख लीजिए जो आपको लगे कि स्पेसिफिक आपको टच बेस जरूर करना है, अदरवाइज हम सवाल ले लेते हैं सर, जैसे आपको ठीक लगे। मतलब वी आर ओपन सर एज पर यूर डायरेक्ट।
अंडरस्टूड सर, अंडरस्टूड। So this is the CA practitioner or maybe the advocate practitioner's checklist for pre-filing. The limitation, you have to check whether the calculate exact limitation date. Then finance compute the 10% or 25% as case, maybe 25% in case of section 129 appeal. The pre-deposit requirement is important. Then documentation, obtain a certified copy or authenticated copy of the order. The merits review, the decide whether to primarily challenge jurisdiction, procedural merit or on the merit ground. That case to case you have to take a call. Then portal execution, ensure that APL 1 is completely and correctly filed before midnight of the limitation date. Attachment mandatory upload include order, pre-deposit challan, statement of fact, ground of appeal and authorization. So this has to be attached mandatorily. If portal glitches prevent filing, immediately capture a screenshot and email the jurisdictional officer to protect limitation right and try to file physical copy. They may not accept, but with the screenshot, so it will be beneficial for you to contest in future. Hearing preparation, monitor the GSTN portal and hearing date. Then oppose any attempt to enhancement of by the department, that also. So what is the summary and the key takeaway? So it is important that at the first stage appeal, it is more critical stage and the fact should be clear and all the fact should be on the record of the department, because this may be the your battleground in your future also. Second, it is important that first stage appellate authority cannot remand back the case. So the professional should ensure every piece of evidence is admitted and analyzed at this stage. Pre-deposit is non-negotiable and limitation period of 30 days, 3 months plus 30 days is also non-negotiable. So you have to comply within that. Draft ground specifically and comprehensively vague ground are should not be there and it has to be very specific. And once you have pre-deposited, then there is no recovery proceeding can be initiated. So these are the some points which is I think important for the participants to summarize. So whatever I discussed was my opinions or views, and opinions or views are like wristwatches. Every watch shows different time from others, but everyone believes that their time is right. So I thanks AIFTP as well as all the participants for attending this program. Yes, sir.
थैंक यू सर। लास्ट में आपने बहुत थॉट प्रोवोकिंग स्टेटमेंट दे दी। वैसे तो सारी प्रोग्राम में ही आपने बड़ी थॉट प्रोवोकिंग दी, लेकिन ये लास्ट वाली फिलोसफिकल थी, तो आई बैक एंड रेड इट केयरफुली। वेरी नाइस सर।
सर क्या करेंगे, जीएसटी में अभी क्या होता है ना, आप कुछ बोलते हैं, मैं कुछ बोलता हूँ, बंसल जी कुछ और बोलते हैं, सब सही है। बिकॉज अभी तक हमारे पास कोई प्रेसिडेंट ही नहीं है, तो ऑल आर करेक्ट।
ट्रू।
ठीक बात है सर। सर योगेश हरजाई हमारे साथ हैं, हमारी इनडायरेक्ट टैक्स कमेटी के मेंबर हैं। योगेश जी, क्या आप क्वेश्चन आंसर सेशन, हाँ, अब ले सकते हैं सर? आप अभी, आवाज नहीं आ रही योगेश जी।
सर यस सर, ले सकते हैं।
प्लीज सर, काइंडली टेक अप द क्वेश्चन आंसर सेशन।
योगेश जी, मेरे ख्याल से मैक्सिमम क्वेश्चंस चैट बॉक्स में आए हुए हैं। क्वेश्चन
चैट
आंसर
बॉक्स
टाइम
में।
में तो दो तीन क्वेश्चंस ही हैं।
हाँ जी।
नहीं, अभी मैंने देखा चैट बॉक्स में एक क्वेश्चन ये था सर कि मेनी हाई कोर्ट हैव हेल्ड दैट ऑर्डर सर्व्ड ऑनलाइन इज अ वैलिड सर्विस ऑफ नोटिस। यस, मेनी हाई कोर्ट हैव सेड कि इट इज अ वैलिड सर्विस ऑफ नोटिस। एक बार आपके पोर्टल में, सर्विस पोर्टल में डाल दिया तो वो तो एक हम सबको पता है। मैंने खाली एक एक्सेप्शनल केस लिया है, कहीं कुछ फंस जाए, कुछ हो जाए, तो आपके पास एक ये है, बट वेदर कोर्ट विल एक्सेप्ट और नॉट वी डोंट नो, बट जजमेंट्स आर देयर बोथ द साइड्स। यस
Sir,
सर।
in this,
सर
I understand Bombino is the landmark decision which has in recent recently been delivered by this Allahabad High
Yes,
Court.
Allahabad High Court.
High
Correct,
Court.
sir. That's why it is in the benefit of SSC. That's why I am taking this
Exactly.
judgment.
Mhm.
The first question is from Mr. Prashant Limai. When the order is actually served on the SSC?
So as we said, there are various mode of communication. Maybe the hand delivery, maybe by courier, speed post, or postal department, maybe via email, or maybe via uploading on the portal. तो जिस दिन पोर्टल पे अपलोड किया, that will be the date of communication. जिस दिन मेल पे भेजा, उस दिन date of communication है। स्पीड पोस्ट के केस में जिस दिन स्पीड पोस्ट को दे दिया, बिकॉज वेरियस हाई कोर्ट हैज हेल्ड दैट डिलीवरिंग कम्युनिकेशन टू द स्पीड पोस्ट इज द डेट ऑफ कम्युनिकेशन। सो अकॉर्डिंगली वी हैव टू टेक अ कॉल, बिकॉज मैं बाकी सब में नहीं जा रहा, न्यूज़पेपर और ये सब, तो दैट इज द एक्सट्रीम केसेस। उसके पहले डिपार्टमेंट ने काफी कोशिश कर ली है, इसके लिए आई एम नॉट गोइंग इन टू दैट डेट ऑफ कम्युनिकेशन।
विवेक सहगल जी का सवाल है सर, डीलर डिड नॉट फाइल GST 9 फॉर ईयर 2017-18 to 21-22. Up to which year notice under section 74 can be issued?
So whether you file or not, it is saying that due date of filing of annual return. So the due date of filing of annual return, अगर मैं बात करूं फॉर एग्जांपल 25-26 की, तो 25-26 का मेरा 31 दिसंबर 26 है। मैं 31 दिसंबर 26 को फाइल करूं या नहीं करूं, मेरा जो लिमिटेशन पीरियड है वहीं से शुरू होगा।
सर ये एक्चुअली एक छोटा सा मेरा सवाल था, बीच में मैंने डाला था। आई वॉज गोइंग थ्रू इंफॉर्मेशन टेक्नोलॉजी एक्ट सेक्शन 13 सबसेक्शन 2।
योगेश
तो
जी,
जो भी, हाँ जी सर।
आप ऐसे ना करो, आप पहले लोगों के सवाल लो।
नहीं वो लाइन में था सर, ठीक है सर, बाद में ले लेंगे।
योगेश जी ने अपना सवाल चैट बॉक्स में पहले लिख दिया था कि आई मीन क्यों।
नहीं नहीं, योगेश जी ने ऑलरेडी लिखा हुआ है, तो सर वो भी लाइन पे है, तो उनका बनता है मेरे हिसाब से। बाकी
नहीं, इट्स
यू
ओके,
टेक द
इट्स
कॉल।
इंपॉर्टेंट क्वेश्चन सो।
क्या था? आप अभी बाद
सर
में, सेक्शन 13 वो मैं पढ़ चुका हूँ, आप क्या कहना चाहते हो? अभी रुक जाओ।
ठीक है सर। नेक्स्ट क्वेश्चन सर पीके गंभीर जी का है। ऑर्डर इन ओरिजिनल वाज पास्ड अंडर सेक्शन 7310 एक्स पार्टी बीइंग अग्रीव्ड एसएससी फाइल्ड एन अपील टू दिस ऑर्डर। दिस अपील वाज डिसमिस्ड because it was barred by limitation. After that assessee filed rectification because order was not matching with the show cause notice. The amount in order was more than show cause notice. So that order was rectified by the assessing officer. Now they have again filed the appeal against the rectified order. and Commissioner Appeal has said them to approach either High Court or Tribunal.
नहीं नहीं, कम अगेन बिकॉज देयर आर वेरियस डेट.
सर
सो एक ऑर्डर पास किया उन्होंने.
एक्स पार्टी हो गया.
अच्छा, एक्स पार्टी हो गया, बट दे हैव गिवन द अपॉर्चुनिटी ऑफ पीएच इशू किया है उन्होंने.
यस, एक्स पार्टी हुआ, अपील फाइल हुई, बट अपील वाज बार्ड बाय लिमिटेशन, वो लेट फाइल हुई होगी, तो अपील डिसमिस हो गई. लेटर दे रियलाइज कि जो ऑर्डर इन ओरिजिनल है इट इज गोइंग बियॉन्ड द शो कॉज नोटिस, तो दे फाइल्ड फॉर रेक्टिफिकेशन ऑफ द ऑर्डर. That order was rectified by the officer. Now they have filed appeal again against the rectified order. तो अपील जो एपरेट अथॉरिटी है उसका कहना है कि आप ट्रिब्यूनल जाएं या हाई कोर्ट जाएं, हमारे यहां से हो चुका है.
सर देखो, प्रैक्टिकली तो अभी क्या है, आप इधर कितना भी झगड़ा करोगे तो कुछ होगा नहीं, या तो आप हाई कोर्ट ही जाना पड़ेगा. बिकॉज वंस दे आर नॉट एक्सेप्टिंग, सो व्हाट रेमेडी यू हैव. एंड अगेन वो देखना होगा कि वो 73 74 के पीरियड ऑफ लिमिटेशंस में है क्या नहीं है, या उसके बियॉन्ड उसने रेक्टिफिकेशन ऑर्डर पास कर दिया है. बिकॉज देर इज सम टाइम लिमिट ऑल्सो फॉर रेक्टिफिकेशन ऑफ ऑर्डर. 3 मंथ्स का है ना, समझो. सो मेरा अगर जैसे 73 का नोटिस है, वो विद इन 3 years उसने ऑर्डर पास करना चाहिए. ऑर्डर के 3 months में रेक्टिफिकेशन होना चाहिए, बट समझो ये बियॉन्ड 4 साल हो गया. So whether that order is valid, that rectification powers are there, again that challenge issues are there. So it is better to go to High Court, and High Court may again remand back to adjudicating authority, then they can take up this matter. This is my practical view.
और गंभीर साहब, आप कोर्ट में जाना बहुत आसान है. ये फोन आ गया आपका सेपरेट.
So next question सौरभ गोयल जी का है. What are the acceptable grounds for condonation of delay?
So that already I have covered in my presentation. Condonation of medical ground है, या फिर death of relatives etc. So these are the grounds. So कौन से हैं और कौन से नहीं है, मैंने दोनों दिए हैं based on the various judgment passed by the different court till now.
Next question सर शोएब जी का है.
And I have already shared just now my presentation to Arora ji. So participants will get the presentation also. तो उसमें ये सब दिया हुआ है सर.
What is the date of communication? Notice on portal or physical notice receiving date?
Whichever is earlier. तो जो जल्दी मिल गया सर. यू कांट से कि नहीं मुझे फिजिकल भी मिला है, लेकिन फिजिकल 10 दिन बाद मिला है, तो मैं 10 दिन बाद का डेट पकड़ूंगा, तो दैट इज नॉट करेक्ट.
Next is sir, whether there is a requirement of submitting the hard copy of appeal once it is filed online.
No, there is no requirement to file hard copy of any appeal. You have to file online only. समझो कोई ग्लिचेज है, कुछ है, देन वी रिकमेंड कि ठीक है आपका फाइल नहीं हो रहा है, स्क्रीनशॉट के साथ आप ले जाके कोशिश करो कि वो फिजिकल कॉपी ले ले, ताकि अगर आपका टाइम बारिंग केस है तो वो अटके नहीं, 3 महीना या ऐसा निकल रहा है तो. अदरवाइज यू हैव टू फाइल अपील ऑनलाइन ओनली.
तो अखिलेश गर्ग जी का है सवाल. उनका कहना है कि टाइम लिमिट ऑफ अपील फाइलिंग सारे एक्ट्स में है, लेकिन कॉन्डोनेशन का टाइम जो फिक्स गिवन है वो सिर्फ जीएसटी में ही है और किसी एक्ट में नहीं है, तो इसके पीछे का क्या लॉजिक है?
सर अभी लॉजिक तो हमको पता नहीं है, बिकॉज गवर्नमेंट नेवर शेयर द लॉजिक विद अस. So maybe they don't want to go beyond 1 month, because जैसे मैंने बताया कि अर्लियर लॉ में हमारे जैसे सर्विस टैक्स था या वैट भी लॉ थे, तो उसमें भी इन्होंने कोई ऑर्डर पासिंग का डेट नहीं दिया हुआ था, खाली शोकॉज इशुएंस का डेट दिया हुआ था. बट फॉर द फर्स्ट टाइम दे आर गिविंग द डेट ऑफ ऑर्डर, पासिंग ऑफ ऑर्डर ऑल्सो, विच इज अ वेलकम चेंज. सो दे वांट मे बी वांट टू फॉलो सम स्ट्रिक्ट गाइडलाइन कि इसके बाद के केस चाहिए, पहले के केसेस चाहिए नहीं. मे बी दैट लॉजिक, आई डोंट नो.
अखिलेश भैया ने जैसे क्वेश्चन आंसर सवाल शुरू हुए ना, अनुज जी आकर कुर्सी पे बैठ गए. मुझे पता था इन्होंने ऐसा कोई सवाल दागा हुआ है जिससे स्पीकर जो है वो कहेगा भाई देखो ये तो ऐसे तो होता ही है. अब हमें ये अखिलेश भाई साहब के सवाल ऐसे ही होते हैं. जो अखिलेश भाई साहब आप बिल्कुल सही कह रहे हो, लेकिन सर मैं फिर वही कहता हूँ, एज ए स्टूडेंट ऑफ लॉ माय रिस्पॉन्सिबिलिटी इज टू कंप्लाई द लॉ, to disseminate the knowledge of the law, that this is how it is to be complied. लॉ ऑफ द लैंड बनाने के लिए या तो फिर आप मनीष भाई को, मुझे को फाइनेंस मिनिस्टर बना दो या कुछ कर दो।
नहीं सर, आप ही ठीक है उसके लिए, हम यहीं पे प्रैक्टिशनर ही ठीक है सर।
जी प्लीज कंटिन्यू सर।
So next question, Zalak ji का है, does first appellate authority has the power to issue order directing to conduct de novo proceedings?
देखना पड़ेगा सर।
So, I feel
I'm not sure.
first appellate authority does not have the power to remand back the matter.
या रिमांड बैक तो नहीं कर सकते हैं।
तो वो de novo फिर सर no point having de novo, क्योंकि वो तो फिर से न्यू प्रोसीडिंग शुरू होंगी, तो
Yes.
it cannot be
So
ordered. I
they do
believe it
not
cannot
have,
be
but
ordered.
in the past they have remanded back, and against that the SSC went to the High Court. So that some of the couple of cases also I mentioned. So I don't know क्या किया उसके आगे उन्होंने फिर। डू नो वो तो नहीं होना चाहिए क्योंकि रिमांड बैक ही नहीं है, लेकिन क्या हुआ पता
राजेंद्र सर, आपकी आवाज नहीं आ रही, आप शायद कुछ बोल रहे हैं।
मैं कह रहा हूँ डी नोवो कैसे करेंगे वो?
नहीं। डी नो होना नहीं चाहिए, बट
क्योंकि जब हम 107 देखते हैं और भी, ड्यूरिंग द कोर्स ऑफ एडजुडिकेशन अगर एपेलेट अथॉरिटी के सामने कोई इशू आता है तो उसको सेपरेटली शो कॉज देना पड़ेगा और अपॉर्चुनिटी देनी पड़ेगी। तो वो कोई नया इशू ही नहीं ले सकता, तो डी नोवो कैसे हो जाएगा? अनल करना याद है योगेश जी, एक केस में हम परेशान
जी
हो
हाँ जी।
गए। अनल का मतलब कि रेफर्ड बैक टू द एडजुडिकेटिंग अथॉरिटी। अनुज जी,
ट्रू।
एक अथॉरिटी ने, कोई सेंट्रल अथॉरिटी थी यहाँ पर दिल्ली, अनल का मतलब उसने कहा कि जी आई एम रेफरिंग बैक टू द एडजुडिकेटिंग अथॉरिटी, और लॉ में स्पेसिफिकली लिखा है
इट कैन नॉट बी रिमांडेड बैक।
रिमांडेड बैक।
इट कैन नॉट बी।
कमिश्नर का व्यक्ति था। चलिए
सर
अगला।
नेक्स्ट क्वेश्चन प्रवेश जी का है, SCN was issued under section 74 for mismatch between GSTR 3B and GSTR 7, जो TDS की रिटर्न होगी, बट उनसे पिछले सालों में सेम प्रोसीडिंग्स वाज कैरिड आउट अंडर सेक्शन 73। तो जो 74 का नोटिस आया है इस अलग साल में, इज इट अ वैलिड नोटिस?
ये परवेज साहब हैं सर, ध्यान रखिएगा, ये जम्मू कश्मीर में स्टेट ऑफिसर हैं, सीनियर।
नहीं नहीं सर, सबसे पहली बात तो मैं ये जानना चाहूंगा कि 73 और 74 मेरा आज का टॉपिक नहीं है। सो फिर भी मैं उस पर कमेंट कर देता हूँ। आउट ऑफ सिलेबस क्वेश्चन है, बट मेरा ये मानना है कि अगर आपका कुछ भी मिसमैच है तो वो तो पोर्टल पे ही है। So can you say that there is a separation of fact with the intention to evade tax? So whether it will fall under 74, I strongly believe that this will fall under only and only 73. So आपका जो 3 साल का लिमिटेशन पीरियड है उसी में ये बैठेगा, बिकॉज दोनों चीजें आपने तो डिस्क्लोज की हुई है डिपार्टमेंट को, पोर्टल पे है ही उनके पास।
There is a Xiaomi case of Delhi High Court, I understand, where the mismatch is related to returns. Section 74 cannot be invoked in that case, sir.
Yes, and there are judgments also.
Other decisions
Various
also.
judgments, various court
Various decisions. Xiaomi was the first one.
2A 3B के केस में और कई केसेस में दिया है उन्होंने, तो
Exactly.
same will apply.
Exactly.
The next question रोहित कुमार जी का है कि व्हाट इज द टाइम लिमिट टू कंप्लीट अपील प्रोसीडिंग्स बाय डिपार्टमेंट? इनकी अपील सर 2 साल से पेंडिंग है, ये या तो दिल्ली स्टेट में होगी इनकी तभी पेंडिंग है, बाकी जगह तो हो ही रही है।
सर देखो, अपील का इन्होंने ऑर्डर पासिंग का कोई टाइम लिमिट नहीं दिया है। फर्स्ट एजुडिकेटिंग अथॉरिटी का टाइम लिमिट दिया है, बट अपील को उन्होंने फ्री हैंड दिया हुआ है। तो खाली फाइलिंग ऑफ अपील का डेट है, ऑर्डर का नहीं है। यस सर।
ये जी
नेक्स्ट क्वेश्चन। हाँ जी सर।
पिछले क्वेश्चन में जो परवेज साहब ने सवाल पूछा था, मेरा माइक नहीं चल रहा था तो मैं बोल नहीं पाया। उन्होंने सवाल पूछा था कि एक साल में 73 हुआ और दूसरे साल में सक्सीडिंग ईयर में 74 हो गया। एम आई
सेम
करेक्ट?
इशू। यस सर, सेम इशू, मिसमैच।
तो क्या ये संभव है? मतलब क्वेश्चन ये है कि पहली बार आप कह रहे हो डिफरेंस को कि भाई ये तो विदाउट द इंटेंट ऑफ फ्रॉड है, और दूसरी बार आप सेम इशू को ला रहे हैं तो कह रहे हैं कि जी विद द इंटेंट ऑफ फ्रॉड है। इसका मतलब तो चेंज ऑफ ओपिनियन है ऑफ द असेसिंग ऑफिसर, प्रॉपर ऑफिसर।
आई एग्री विद यू कि आप दोनों दोनों पे आपको फाइट करना चाहिए। ये पॉइंट जो है मैंने मिस कर दिया था। तो एक साल में भी अगर आपने समझो प्रीवियस ईयर में भी 74 लगाया है, तो नेक्स्ट ईयर में सेम इशू पे क्या 73 लगेगा, 74 लगेगा? मेरे हिसाब से जब आपको इशू पता है तो 73 में ही जाना चाहिए। यू कैन टेक द एक्सटेंडेड पीरियड ऑफ लिमिटेशन इन दिस सिनेरियो।
वैसे भी कंसिस्टेंसी को फॉलो करना पड़ेगा डिपार्टमेंट को। डिपार्टमेंट एक साल एक पर्टिकुलर व्यू लेता है किसी पर्टिकुलर ऑफेंस के लिए, दूसरे के लिए नॉन कंप्लायंस के लिए दूसरा व्यू लेता है। ये संभव नहीं है। इसका सिर्फ एक ही कारण है, टू इन्वोक द एक्सटेंडेड पीरियड ऑफ लिमिटेशन।
सर परवेज जी का एक क्वेश्चन है फिर से। Rectification application was rejected by proper officer on the ground that application was filed beyond time limit of 3 months. Appellate authority annulled the rectification order and sent the case for reassessment of the original order passed under section 73.
The first appeal can remand back. That is the my question, because there is no power ना।
सर वो अभी राजेंद्र सर बात करते हैं एनल्ड वाला, सर वो आ गया सर एनल्ड।
लेकिन योगेश जी ये थोड़ा मुझे डिफरेंट लग रही है बात। सर यहाँ पर क्वेश्चन ये है कि मेरा जो ऑर्डर हुआ उसके अगेंस्ट मैंने रेक्टिफिकेशन फाइल की, और रेक्टिफिकेशन का
रिजेक्ट हुई,
रेक्टिफिकेशन रिजेक्ट हो गई।
रिजेक्ट हो गई, उसके अगेंस्ट अपील फाइल कर दी।
अपील फाइल की तो उसके अगेंस्ट जो ऑर्डर दिया जाएगा 107 में, वो तो ये दिया जा सकता है ना कि चले जाओ जी, रेक्टिफिकेशन आपकी मैं अलाउ करता हूं, या मैं आपको अपॉर्चुनिटी देता हूं कि आप जो है इसको रेक्टिफाई करवा लो अगर ये अपेरेंट मिस्टेक है फ्रॉम द रिकॉर्ड।
सर अगेन सर वो आपका बात बिल्कुल ठीक है, बट अगेन डिपेंडिंग ऑन अपील में क्या फाइल किया गया है, वेदर इट इज फॉर ओनली रेक्टिफिकेशन या फिर जो प्रिंसिपल मैटर था उसको भी कवर किया है।
देखिए प्रिंसिपल मैटर की तो बात होगी ही नहीं ना रेक्टिफिकेशन में। रेक्टिफिकेशन में तो अपेरेंट एरर, और वहां पर तो साफ साफ सुप्रीम कोर्ट ने कई जजमेंट्स में कहा है कि जहां पर भी एप्लीकेशन ऑफ माइंड होना है वो रेक्टिफिकेशन है ही नहीं, वो स्कोप में ही नहीं आता उसके 161 के।
वो मैंने देखो इसमें भी कवर किया है सर, आप देखेंगे प्रेजेंटेशन में तो जैन एप्लीकेशन ऑफ माइंड जो है वो आएगा ही नहीं। सी रेक्टिफिकेशन ऑफ एरर में क्या क्या क्वालिफाई नहीं होगा। क्या क्वालिफाई होगा इज अर्थमेटिकल एरर, मिस्टेक, क्लेरिकल एरर एंड एनी इडवरेंट omission, and which will not qualify is reappreciation of evidence, changing a legal view, or filing a gaps in the authority's reasoning will not be qualified as rectification of error.
बिल्कुल ठीक है।
So ये डिफरेंट कोर्ट ने ऑलरेडी ये सब हेल्ड किए हुए हैं चीजें, व्हाट इज रेक्टिफिकेशन ऑफ मिस्टेक अपरेंट फ्रॉम रिकॉर्ड एंड व्हाट इज नॉट।
बिल्कुल ठीक है सर।
कैन असेसिंग अथॉरिटी रेक्टिफाई द ओरिजिनल ऑर्डर सुओ मोटो?
Yeah, assessing authority dot what we discussed, if there is a mistake apparent from record, so within 3 months that time limit is there ना।
लिखा तो either on his own motion or error brought to the notice by the।
बाय द एसएससी, तो दोनों तरीके से कर सकते हैं। उनको लगेगा कि उन्होंने खुद में खुद सो मोटो भी कर सकते हैं।
मेरा माइक बार बार बंद हो जाता है।
सर वो इसलिए हो रहा है क्योंकि 7 के ऊपर हो गया ना।
अच्छा अच्छा। चेयरमैन पीछे से बंद कर देते हैं, तू बहुत बोल रहा है, मनीष जी को बोल।
The pre-deposit, is it to be paid when the appeal is filed or treated as filed, or it can be paid while presenting the appeal?
सर बिकॉज मैंने जो बताया चेकलिस्ट आपको दिया है कि वंस यू आर फाइलिंग अपील APL 1, तो उसके साथ में आपको इसका चालान अटैच करना है। सो इट हैज टू बी पेड बिफोर फाइलिंग ऑफ एन अपील।
So does tribunal have the power to condone delay beyond 1 month?
सर वो अगले अगले सेशन में अरोरा जी कवर करेंगे ट्रिब्यूनल के पावर्स।
ठीक है सर, मैं ध्यान रखूंगा स्पेसिफिक।
सर अगर मैं उनके जुरिडिक्शन में जाऊंगा तो प्रॉब्लम होगा ना।
प्लीज सर, ऐसा।
In case order is received physically prior to uploading on the portal, while filing the appeal, the portal takes the date on uploading of portal order on portal. So the decisive date is date on which order was uploaded on portal. मतलब इन्होंने रमेश वाधवा जी ने अपना एक I guess opinion share किया है. If order was received physically पहले, later on it was uploaded on portal, and when we are filing the appeal, it considers the date जब वो portal पे upload हुआ है.
ओके, ठीक है ना। तो आपको लेटर डेट मिल रही है तो अच्छा है।
सर
सी
वैसे
एक स्टार्टिंग में शायद हम बात कर रहे थे, अरोरा जी ने पॉइंट बिफोर स्टार्ट ऑफ द मीटिंग वी वर जस्ट डिस्कसिंग दैट वेरियस पॉइंट्स आर देयर कि वो पोर्टल अपने हिसाब से चलता है। सो इसमें आप लॉ क्या है और पोर्टल क्या है, दीज आर द टू डिफरेंट थिंग्स, so which we cannot comment on that.
Assessee prayed for adjournment against DRC 01A. Adjudicating authority issued DRC 01 without fixing further date for compliance of DRC 01A. Whether GST department has to decide not to grant any opportunity to taxpayer and proceed to pass order ex parte. 1A दिया, उसके लिए एडजर्नमेंट मांगी, बट कोई एडजर्नमेंट नहीं मिली, 1 कर दिया। तो क्या
नहीं
डिपार्टमेंट अब टाइम नहीं देने वाला हमें?
नहीं, इसमें सर पहले तो देखना पड़ेगा कि वो मेरा 3 इयर्स का पीरियड या 5 इयर्स का पीरियड खत्म हो रहा है नहीं हो रहा है, क्या है, व्हाट इज द फैक्ट्स एग्जैक्टली। बट एक्स पार्टी ऑर्डर किया तो डेफिनेटली यू कैन फाइल एन अपील एंड डेफिनेटली उस टाइम पे आपको 10% भरना पड़ेगा बिकॉज यू हैव नो अदर ऑप्शन टू गो टू द अपील अथॉरिटी इफ दे हैव डन लाइक दिस। बट एक्स पार्टी ऑर्डर तो ऑलरेडी वी डिस्कस कि यू कांट इशू एक्स पार्टी ऑर्डर, एंड इसमें तो स्पेसिफिकली वन हाई कोर्ट का जजमेंट है विच आई मिस्ड इन माय प्रेजेंटेशन, विच सेज कि अगर उसने नहीं भी मांगा है अपॉर्चुनिटी ऑफ हियरिंग तो यू हैव टू गिव। बट इफ एनी टाइम लिमिट इज नॉट बियॉन्ड टाइम लिमिट जा रहा होगा 3 इयर्स या 5 इयर्स एट द केस में भी, तो मे बी पॉसिबल।
योगी
कैन एडिशनल ग्राउंड बी रेज्ड एट द टाइम ऑफ हियरिंग?
क्वेश्चंस ले लीजिए सर प्लीज ना, इट इज अ रिक्वेस्ट नाउ बिकॉज इट इज ऑलरेडी पोस्ट 7।
तो कैन एडिशनल ग्राउंड ऑफ अपील बी रेज्ड एट द टाइम ऑफ हियरिंग?
ऑलरेडी आई डिस्कस कि आप कौन कौन से ग्राउंड ऑफ अपील एडिशनल आप ले सकते हैं प्रेजेंटेशन में, इट्स ऑलरेडी देयर द 4 ग्राउंड व्हाट आई हैव ऑलरेडी कवर्ड कि विच इज मैंडेटरी फॉर अपीलेट अथॉरिटी टू एक्सेप्ट which they cannot deny. And at the time of hearing also, practically what I have seen, कि if your points are genuine, then they allow you to take at the time of hearing also. And many cases we have further submitted the after the hearing also we have submitted the ground in which passing order appellate authority has considered.
So whether any affidavit is required to be filed along with condonation of delay?
देखना पड़ेगा सर, इट इज ऑफिसर टू ऑफिसर बिकॉज लॉ में ऐसा कुछ दिया नहीं है कि आप एफिडेविट फाइल करो या जो भी है। सो इफ यू आर इन अ हॉस्पिटल एंड इफ यू आर प्रोड्यूसिंग द हॉस्पिटल बिल, सो इट इज अ सफिशिएंट ग्राउंड।
ये एपेलेट अथॉरिटी लेवल पर योगेश जी एफिडेविट की कोई प्रथा या एक्सपेक्टेशन नहीं है यहाँ पे, है ना। तो आप अगर एक प्लेन पेपर पे एक रिक्वेस्ट लगा दीजिए कॉन्डोनेशन की सेपरेट अलोंग विद दी, और बहुत ही सुंदर तरीके से मनीष भाई ने उसमें बताया कि कौन कौन से डॉक्यूमेंट्स सिचुएशंस एक्सेप्टेबल होंगी और कौन सी एक्सेप्टेबल नहीं होंगी फॉर कॉन्डोनेशन। और पीपीटी की जहां तक बात है, पीपीटी ऑलरेडी मेरे पास है, मनीष भाई ने दे दी थी। मैं अभी चेयरमैन साहब को भेज दूंगा और वो चेयरमैन साहब आगे सबको भेज देंगे।
Done.
लास्ट क्वेश्चन इज फॉर जीएसटी अपीलेट ट्रिब्यूनल। आई गेस अगर वो टॉपिक नहीं है तो नेक्स्ट टाइम वी आर कवरिंग इट,
नेक्स्ट
तो
टाइम
विल लीव इट फॉर दैट।
या
आप, मैं दे दूंगा जवाब, आप बोलिए, पूछिए।
What will be the biggest practical challenge before GST appellate tribunal in its initial time procedural delays, judicial consistency और technical interpretational issues?
अरे ये एक सवाल छोड़ना है
सर
सर।
ये क्वेश्चन नहीं
ये
है तो
पूरा
पूरा
सोशल
सेशन
पूरी
topic है, इसके लिए मैं
प्रेजेंटेशन
कुछ
अपने आप में
कमेंट
सर
नहीं
ये
कर रहा हूँ इसके ऊपर।
है।
एक सवाल नहीं है, ये तो पूरे 2 घंटे।
वही कह रहे, दो
तो
घंटे
बड़ा
की
पूरा
प्रेजेंटेशन है
सेशन
सर
है
ये।
सर वो।
टेक्निकल इश्यूज, जुडिशनल इश्यूज एंड लीगल इश्यूज।
जी सर।
So that's it, sir. Questions members के तो हो गए सारे।
चलिए, तो मैं यहाँ पर आई एम अज्यूमिंग द रिस्पॉन्सिबिलिटी ऑफ प्रपोजिंग फॉर्मल वोट ऑफ थैंक्स ऑल्सो टुडे। आप देखिए मनीष भाई, अभी भी लगभग 65 लोग जुड़े हुए हैं, लगभग 1.25 घंटे बाद ऑफ द प्रोग्राम, स्टार्ट ऑफ द प्रोग्राम। सो दिस इज योर मैजिक, दिस इज योर करिश्मा, दिस इज योर बॉन्ड. So I would like to extend a great thanks, a warm welcome to our platform, to you, Manish bhai, and we will be looking forward to more in times to come also कि आप हमारे ऐसे ही हमारे इनविटेशन को ग्रेशियसली एक्सेप्ट करेंगे और अपनी नॉलेज से हमारे पूरे भारत के चार्टर्ड अकाउंटेंट, एडवोकेट्स और बाकी टैक्स प्रैक्टिशनर्स का मार्गदर्शन और उनका मनोबल बढ़ाएंगे। इतने सारे सवाल और इतने अच्छे तरीके से आपने, फैंटास्टिक। मैं पूरे टाइम आई वॉज ग्लूड टू, बिकॉज मैं तो एक स्टूडेंट हूँ, मुझे हमेशा कुछ लगता है कुछ नया मिले, कुछ और करूं अपनी बातों को। आप जैसे विद्वान व्यक्ति जब कुछ बोल रहे होते हैं तो मेरी बातें और री होती हैं, तो आई फील सो बेटर एंड कॉन्फिडेंट। तो मैं यहाँ पर चेयरमैन हमारे अनुज बंसल जी का भी बहुत बहुत आभार व्यक्त करता हूँ, जो एक एक पूरी स्ट्रॉन्ग पिलर की तरह हमारे साथ पीछे खड़े रहते हैं और जहाँ पर भी हमें ज़रूरत होती है हमें सपोर्ट देते हैं। साथ ही साथ हमारे डिप्टी प्रेसिडेंट, नेशनल प्रेसिडेंट एडवोकेट संजय कुमार जी का भी बहुत बहुत आभार व्यक्त करता हूँ कि उनकी लीडरशिप में हमारा जोन जो है, क्योंकि हम प्राउडली फील करते हैं क्योंकि वो हमारे जोन से हैं, हमारे नॉर्थ जोन से ही डिप्टी प्रेसिडेंट है और भविष्य के प्रेसिडेंट है हमारे वो। तो हम बहुत ही प्राउड फील करते हैं और बहुत ही कॉन्फिडेंट फील करते हैं कि आज कल दोनों समय में हम उनकी लीडरशिप में नॉर्थ जोन और पूरी फेडरेशन को पैन इंडिया एक नई ऊंचाई पर, ऑलरेडी जो इसके साथ लॉरल्स और इसके साथ जो ग्लोरी एसोसिएटेड है उसको हम मल्टीप्लाई करेंगे, मैनीफोल्ड बढ़ाएंगे। और हमारे बीच में इतने यंग, डायनेमिक, एंथुजियास्टिक प्रोफेशनल्स हैं मनीष भाई, यू वुड लव टू बी पार्ट ऑफ अस एंड वी आर लुकिंग फॉरवर्ड ईगरली टू हैव यू ऑन द बोर्ड इन द फेडरेशन। और मैं तो ज़्यादा एक्साइटेड हूँ कि आपका नाम, आप जब इंट्रोड्यूस होंगे तो मेरा नाम उसमें जुड़ जाएगा। सो आई एम मोर एक्साइटेड। तो और मैं सभी यहाँ पर जो हमारे एग्जीक्यूटिव मेंबर्स हैं, हमारे सेक्रेटरी हैं, हमारे ट्रेजरर हैं, हमारे वाइस चेयरमैन हैं, हमारे बाकी कमेटी मेंबर्स हैं, सभी का बहुत बहुत आभार व्यक्त करता हूँ उनकी सपोर्ट के लिए, उनके साथ के लिए, उनकी कंसिस्टेंस एक गाइडेंस के लिए बहुत बहुत धन्यवाद। और सभी पार्टिसिपेंट्स, क्योंकि वही प्रोग्राम की जान होते हैं, वही प्रोग्राम को एक सोल देते हैं, तो उनका बहुत ज़्यादा, सबसे ज़्यादा उनका आभार व्यक्त करता हूँ। और भविष्य में ऐसे प्रोग्राम्स करने का आपको हम अपना कमिटमेंट देते हैं कि जब तक हम चाहेंगे, मतलब जब तक हम कोशिश करेंगे, हमारे साथ हमारे सीनियर्स हैं हमारे, तब तक हम जो हैं ऐसे प्रोग्राम्स नॉलेज अपडेशन के, क्योंकि मैं समझता हूँ कि जो पढ़ेगा वही बढ़ेगा और ज्ञान एकमात्र साधन है इस धरती पर जीवन को सुंदर और सफल बनाने का और ज़्यादा परिपक्व बनाने का। तो हालांकि ज्ञान का की कोई अंत और सीमा नहीं होती, लेकिन जीएसटी के ज्ञान में यहाँ पर भी समंदर है, लेकिन हम कोशिश करते रहेंगे कि समंदर में डूबते रहें, गोते लगाते रहें और गहरे जाएं और मोती और अमृत सब प्राप्त करें। तो इसी के साथ मैं आप सभी का एक बार फिर से आभार व्यक्त करता हूं, धन्यवाद देता हूं और सभी को बहुत बहुत साधुवाद और बधाई देता हूं इतनी देर तक जुड़े रहने के लिए। मनीष भाई बहुत आभार, अनुज जी।
थैंक यू मनीष भाई, वंडरफुल प्रेजेंटेशन। थैंक यू राजेंद्र जी, थैंक्स।
थैंक यू सर, थैंक्स फॉर इनवाइटिंग मी। थैंक यू।
Thank you.
So now we are formally closing this webinar.